Call me crazy, but the fact that Darrell Brooks could represent himself again in his appeal is ridiculous, to say the least. The nonsense and absurdity he displayed in his trial should be enough to never let him represent himself again. For example, he could not follow the rules of procedure in the court, and he either ignored the judge or argued with her every time she tried to bring it up.
We have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by your honor? That's a valid question.
Mr.
Because
Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even get these admitted into evidence.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right, I don't understand. But
that doesn't mean we're going to have a discussion or a debate about what it means, because we're not going to do that.
The rules that you said.
So the bottom line is, I don't feel, Mr. Brooks, stop talking. I was
following the rules when you said that I had to make all
objections. And you did, and I'm going through them. So give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All
Brooks,
I'm saying is,
I'm going to address the next one, so please pay attention.
What you were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr. Brooks, again, you have the right to present a defense, but that right is not unfettered. That right, Mr. Brooks, you are interrupting me. Stop.
Because you're talking about
because you're purposely doing this, so I can't get my reasoning out. You make it incredibly difficult.
I'm not referring to the Sixth Amendment.
Mr. Brooks.
I'm referring to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial.
Mr. Brooks, you also have an obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence. That's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right now.
You also accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract
We did not.
or engage in
We did
any
not.
type of
We
that
did not
kind of
enter into
dialogue,
any
because
contract.
that's what you're claiming through some
No,
of these
I'm not.
filings,
I'm
and
not
you've said
claiming
that previously.
I am not claiming that, Your Honor.
So,
In any way,
Mr.
shape, or
Brooks,
form,
I
do
am
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, you please, I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's being asserted on my
Here's what's
end.
happening, sir.
All
I'm
I'm-
telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. And then I'll bring you back when the jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing this court with the
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor my First Amendment right?
I'm
Or
not
are you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination,
So
sir.
you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have a
Sixth
right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
your
are,
rights,
Your Honor. You're citing the Sixth Amendment, which I am not
Mr. Brooks.
questioning.
Your
I'm-
First Amendment, in some respects, is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So it
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And it
Honor.
doesn't mean you get to put forth any kind of evidence that you want
Your
in front
Honor,
of a
am
jury.
I
What it
being-
means, sir,
am
is
I being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeit his right to be
I have
present
not
as I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor,
everything
I do
set
not
up.
agree to a
The
estoppel.
record-
Or how about all the times he tried to intimidate the witnesses or the judge? He was constantly fighting with her and trying to act tough.
So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
Objection. Your Honor, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained
How
is
can
to
you
the
recall
form
some
of the
details and not
question.
others? Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recall.
Objection.
Don't-
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue. What do you mean?
Next question.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611, please ask your next question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can be. Mr. Brooks, I've made my ruling under 90611. Please ask a question or I will stop the questioning.
How did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this witness will end.
How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62Q trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text, or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you.
Also, he was put in the other courtroom because of misconduct more times than I can count.
Sir, you are simply in a different courtroom based upon your disruptive behavior. I'm giving you the
has not been disruptive.
I've put my findings on the record, sir, and the record stands in that regard. I'm giving you the opportunity, if you can, indicate to this court that you will conduct yourself with courtesy and decorum. Are you willing to do that, sir?
Is Your Honor willing to tell me why I've been held in contempt?
I did not hold you in contempt, sir. I've already indicated that.
Removing me from the courtroom is like holding me in contempt.
I didn't hold you in contempt. You were removed pursuant to the authority given to me by the United States Supreme Court in Illinois versus Allen, based on your disruptive behavior.
And throughout the trial, he consistently objected to being called Darrell Brooks. So how can he represent himself, Darrell Brooks, if he's not Darrell Brooks?
I'm going to ask Mr. Brooks one more time if he would like to come back to this courtroom and if he's willing to conduct himself with dignity, respect, and decorum.
But for the record, I don't consent to being called that name, and I never stated that I wanted to be removed from the courtroom.
And lastly, he was extremely immature during a lot of the trial, which tested everybody's patience as they waited for his tantrums to subside and ended up extending the trial.
All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times This morning alone, he started interrupting this court within a minute of the court calling the case.
So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at
finish.
the end of the day,
Let him
if
finish,
we gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he
Don't
can
sit
show
there and try
it
to
is
think you know what's
inadmissible,
going
he will
on.
not be questioned. And under 906.11, I will
Then you gonna
declare
talk
the
about where my
cross-examination
kids live. You don't know where,
closed.
You don't know where, what
Thank
happened
you.
at
We're
the
in
time
recess,
when all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going to
do you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption. All rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.